Case People versus Randall Laird. This is AG. This is for AG.
Morning, Your Honor. Assistant Attorney General Doris Williams on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Dottie Lebo on behalf of Mr. Laird, who I believe appears by Zoom. Mr. Laird, please state your name, sir.
Yes, sir. Randall Laird.
I need a camera, sir.
I'm working on it. I'm sorry.
What are we doing?
You're going to be requesting an adjournment. I did just receive full information on the potential offer this morning, which I'd like to review with Mr. Laird.
I put that on the AG case. 26. Yeah, so let's do it that way. All right, probable cause conference in this case will be during February 26, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Case People versus Andrew Patton.
Oh, that was it, I guess.
Yeah, that was it. Unless you want me to do something else, but people normally don't. Thank you, sir. All right.
Good morning, Your Honor. Charlotte Steffen on behalf of Mr. Patton.
Thank you. Mr. Patton, can you state your name, please? Just Mr. Patton. Thank you. What are we doing?
Your Honor, we have reached a resolution of this matter. Mr. Patton is signing the plea form and the advice of rights form. The people have offered to reduce this to the use of cocaine, a 1-year misdemeanor.
He's going to plead guilty to that charge.
Yes, he is, Your Honor.
All right. The plea form that I have in front of me now indicates that the defendant will be pleading guilty to the charge of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed.
That's correct.
That's the court's full understanding of the agreement. May I have it sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, please.
Andrew Spencer Patton.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine.
Yes, sir.
That's a misdemeanor punishable by up to 1 year in jail and a $1,000 fine plus court costs. You understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case.
Yes, sir.
And that you would be sentenced before Judge Perry in the 15th District Court.
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
because you believe that you're guilty?
Yes, Your Honor.
May 16, 2025, at the location of North Huron Street, City of Ann Arbor, Washington County, State of Michigan. Did you have cocaine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
And did you know what you were using was cocaine?
Yes, Your Honor.
Sir, if I accept your plea between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No.
I can't afford testing is not a magic excuse. Judges treat testing like the price of being free. The judge's logic is cold but consistent. If you can't comply, you'll be back anyway.
And have I complied with the court?
Yes.
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
February 27th at 8:30 before Judge Perry.
February 27, 2026, 8:30
Your Honor, may I address bond?
before Judge Perry as to bond.
Thank you, Judge. Your Honor, Mr. Patton is in custody on a bond violation for failure to test. It's my understanding that he was reporting as directed, but didn't have the funds to test. He also believes there was some discussion at the time that the bond was set, indicating if he was not able to afford testing, that he would not be in violation. So we are respectfully asking if Your Honor would reinstate the bond. Thank you, Judge.
Any response from the people?
Here's the question.
Are you gonna be able to test?
Yes, sir. I mean, I can't afford it, but I can test clean. I can't afford it.
Or you're gonna have to find a way to?
I can find a way.
to test. Because if I let you out, we're gonna end up in the same boat again. If you don't go over there and don't test.
I can go test. I can either pan out or do something to make that money up, but I can, yes, sir.
I'll grant the motion for a bond reduction. Previous bond is reinstated. with
Thank you,
its
Your Honor.
conditions.
Thank you, Your Honor.
Thank you. This is what I need to do. CC over. Just want it put back to where it was. Court does call the case People versus Michael Padola.
David Kenny for the people, Your Honor.
Yeah, I see him. Here's his attorney. Who's his attorney? Mr. Bennett? Really? Mr. Bennett? Sir, state your name.
Michael Bedolla.
I'm gonna pass your case. We gotta wait for your attorney to show up. And
Okay.
He's on the Zoom screen, but not responding. All right, I'll pass that case. Court does call the case of People versus Cadena South.
And then we have the people.
Your Honor, I'm sorry, did you call Bedolla? No, you didn't.
Good morning, Your Honor. Christina Saxon on behalf of Mr. South. Please state your full name for the court. Kadena Gill Self.
Thank you. You're requesting an adjournment.
Yes, Your Honor.
You're waiting. You just got appointed. You're waiting video discovery.
Correct.
Is that on its way?
We have it, Your Honor, so it should be.
Probable cause conference will be adjourned then to February 12th,
Your Honor, I'd like to make a bond modification motion.
February 12th, 2026, 9 a.m. Yes, it's the bond.
Your Honor, Ms. Self is being held on $1,000 cash bond. I'm asking for a reduction to a personal bond. It's reported to me that she and the alleged victim do not reside together. He has a different address, so she should be able to return home. And or may not be able to see. She does have a cast on that she will need to go to a physician to address, and being incarcerated, I'm afraid that she won't be able to do that to get it off in a timely manner.
Response.
Your Honor, at this point, I would object. On our bond bill, we requested 25,000 cash period. This involved Ms. Self stabbing the victim in the shoulder with a screwdriver, hit 5 puncture wounds that officers saw. She was also very irate and aggressive at the scene when officers arrived and were berating the victim, and then had to be carried to this car. So I expect that this could potentially be other charges in the future.
Ooh, did you catch that? Defense tried the "it was just words" argument, and the judge basically hit them with "words don't jail you. A screwdriver might." That's the judge telling you, I'm not buying the downplay.
For RNO, but at this point, I would object.
Anything else?
Yeah, I would just say that it was a highly intense situation, and berating, calling someone names does not rise to the level of incarceration. I believe, or additional charges. Calling someone names isn't enough.
Well, the
But as for that's,
stamping with a screwdriver, that would do it, wouldn't it? You don't need to say anything. Motion for bond reduction denied. Bond will continue. Thank you. She's lucky I won't raise it at this point. Court calls case People versus Edna Grima.
Good morning, Honor. Charlotte Steffen on behalf of Ms. Grima.
Good morning, sir.
Good morning.
Your Honor, we're requesting an adjournment for discovery.
The adjournment. Have you seen the progress report?
Yes, I reviewed it with my client this morning, Your Honor.
Why do I have cocaine showing up in her system?
Because, sir, when they test over there, they don't do it the levels. So I've been getting high for 48 years.
What?
Yeah. And so even though it was like, I think the last time was like New Year's Eve or January 5th, one or the other. But you don't show levels, so you don't show it going down, down, down. And therefore, if you got cocaine in your system, you just got cocaine in your system. That's how it is. But that's not okay because it could be in my system for a long, long time, even though I don't get high.
Okay, so just so I'm clear what you're telling me,
Yes.
that on January 5th, you tested positive for cocaine. And that was just,
And I didn't
that was just
expect
something in
it
your
should
system.
not have been.
It shouldn't have been there.
Right.
It's just stuck in your
But you
system.
guys don't do
And
it
then-
by levels.
What?
You don't test it by levels to see if it's going further and further.
Okay, so then the next time you're supposed to test, you missed the test.
Huh?
Then you missed the test.
Oh, I didn't have $12.
Okay. And then the next test, almost 2 weeks later, you're testing and you test positive for cocaine. And so, hold on before you, because I want to make sure I've got your story.
The judge just warned the audience, if you yell, you're going too. That's not a joke. Judges can hold people in contempt instantly.
And so you're telling me that the second test for cocaine was really the same as the first test because it's just stuck in your system because you've been doing cocaine forever.
What I'm
I don't
saying,
know who the heck you are, but if you start yelling in my courtroom, you're going to be going with her.
okay, this what happened on the 5th, to be honest.
What? What happened on the 5th?
I said that, wait, what happened? Let me think.
I don't know. Go ahead, think about it.
Right. What I'm saying is on the 5th, I was dirty. I had used like not that far from there. But I was scared to say so because I was scared to say so. So then the next time I didn't have the $12. And the next time
So
it was
hold on.
still
That's what I was getting at before your fans started yelling out from there.
my sister. She here
Okay,
from
all right, but
out of town.
so you're telling me
Mhm.
this test that showed up positive, you didn't use cocaine,
Which one?
the 20th,
The 20.
last
no,
test.
No, I had.
You had
Since
not
the
used
5th.
any cocaine,
No,
even though you've been using it for years.
right. Right. It should have been clean. I'm saying, I don't understand why it was dirty. But the problem is this, sir. You guys don't check the levels. So you,
Oh,
I
I can check levels.
wish
But
y'all
not,
would.
but, well, I can get the levels.
Okay.
That's not a big deal.
Okay.
Problem is, because you missed the test,
Uh-huh.
if you did a little bit of cocaine, it'll look like it's going down, but you didn't use cocaine still.
Oh,
You should not be testing positive for cocaine 2 weeks later. That's the bottom line. Grant an adjournment in this matter to February 5th, 2026, 9 a.m. That's 1 week out.
Your Honor,
You're
I'm
not
not
available that day?
correct.
That's fine. I'll set it into 12. At this point, the defendant's bond's revoked. She's remanded.
damn.
What'd you say?
Excuse me. I was saying my
You
sister.
know, you need to take yourself on out. What? What last one? Oh, was it? Did you really say that?
Want me to repeat it?
No, that was. You don't get that response. No, she's good. What? You don't want to talk to me about that? No? Okay. Court does call the case of People versus Terry Probst.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Probst, who's making his way into the courtroom, I would assume.
Well, where is he?
Exactly.
Evan is custody.
I don't.
He is in custody, Judge.
Oh,
Just give that back to you. Yeah.
we'll pass it.
Okay.
Court does call the case People versus Quan Patterson.
Freeman Cook. Cal Kavalowski for the people, Your Honor.
What? Who's that?
That's Mr. Probst.
Oh, I'll just take him if you got him. All right, back on the Probst matter.
Morning, Your Honor. Raymond Cook. Date sign there. Michael Gaddy, Assistant Public Defender, on behalf of Mr. Probst, Your Honor. State your name.
What are we doing? Thank you, sir.
Your Honor, these are going to be waivers. I have gone over his rights. He's executing the form now. I've gone over
Sir,
with Mr. Probst.
You're waiving your right to a preliminary examination.
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that's alleged to have committed it. You committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further
Yes, sir.
resolution. People also waive their right.
Yes, Your Honor, there was an offer I can put down on the record.
Yes, go ahead.
The offer was completed to the filing 1391, which came through dismissal filing. Trial.
All right, good.
That is correct, Judge.
Preliminary examination having been waived in both of these matters. Defendant is bound over to circuit court.
Your Honor, in terms of arraignment, we'd waive reading, stand mute, the charge.
Defendant having waived former reading, standing mute, court will enter a not guilty plea. Pretrial will be set for February 11, 2026, 1:30, Judge Conlon.
Your Honor, if I could be heard on bond.
Yes.
Your Honor, I've had a chance to speak with Mr. Probst about this. I've reviewed the file. Mr. Probst is was remanded at his last probable cause conference. He had missed some tests and had tested positive. The positive tests, looking at the violation, were from when he was first arrested. He reports he got a personal bond sometime around December 29th. He the missed tests he reports resulted from a stay in the Wayne County Jail where he was, obviously unable to test. He then reports having gone to community corrections. They indicated that they did not have any record of him needing to be there, and that's why he didn't test on the 29th. I'd ask the court to release him. He does report that he does have a place to stay in gainful employment. I have reached out to the, he gave me a number. I've reached out to the employer. They haven't gotten back to me yet. So, but that's kind of where things stand, Judge. He reports that he would test regularly in this matter.
That's not what my file reflects, his rendition of things. But most for bond reduction tonight, bonds will continue. We'll bring it up.
Thank you, Judge.
Court calls case People versus Quan Patterson.
Alex Jablowski with people.
Is that Mr. Goldstein, Your Honor?
No, Mr. Glowell.
Oh.
Your Honor,
Okay, then.
Mr. Kilowatt is on Zoom in another court,
Who?
He is.
or I'm sorry, Mr. Goldstein is, sorry. He's trying to wrap it up, so he's not gonna be able to come in for a couple of seconds.
Is it Klein here?
Yeah.
Oh, okay.
Client is here. And I don't have stage right.
Why are you sending as the messenger? You wouldn't even stand up at the beginning of the docket. Now you're delivering message. No, I don't want to talk to you. Bye. Court closed the case of the People versus Bradley Potter.
Alan Zend on behalf of the people.
Brown Train on behalf of Mr. Potter. Mr. Goldstein standing in for Mr. Fikowski.
Seriously? Okay, we can't, no.
You want me to go get him?
The one you were delivering messages for.
Tell him Bradley Potter's up.
Bradley.
Sorry.
Your name, sir? Bradley Potter. Thank you. None of this is your fault. This is,
Goldstein standing in for Mr. Fifowski.
do we know what they're doing?
Setting exams,
Setting it for exams?
both of them. Mine
Okay,
too.
so based upon your knowledge, the discovery is complete.
That's my information.
And so you want your matter set for exam? Is that what?
Yes, sir.
All right, very good. Would the people have their witnesses available to 10? Preliminary examination will be set February 10th, 2026, 9 a.m. before Judge Garwood.
Hey, I just said it for you.
Okay.
Bond will continue.
It's February 10th. Judge
Thank
Garwood.
you.
I'll tell Jim.
And, all right, thank you, sir. We already took care of it after we got the message from your messenger cannon.
She couldn't do the waiver of.
That's what I was saying, but she was delivering messages for people. I don't know what her deal.
Judge, I approach in a related matter to this,
To which one?
Mr. Fopowski.
Oh, sure.
I'm standing in for him today, Your Honor.
Or does recall the case of people versus Quan Patterson. Did I finish Quan? Quan Patterson?
David I. Goldstein, appearing on behalf of the defendant.
Your name, sir?
Quan Patterson.
Thank you.
Your Honor, we do have all the discovery, including the videos, and we're asking the matter be set for free.
People have their witnesses available the March 10th. Yeah, that's what I said. Is there a problem with that?
I hear it Your Honor, if I could address bond.
Go ahead.
If I can address bond real quick. My client, the magistrate, for whatever reason, saw fit to place a tether on my client, a GPS tether. It's not a curfew. We're not sure why exactly. He wasn't ordered to do any testing. I've known Mr. Patterson for a number of years. He's a lifelong resident of this county. He is not a risk of flight. He works in this county. He lives in this county. He has family in this county. So we're not sure why the magistrate, I wasn't present at the arraignment, Your Honor. Not sure why he did it. We're asking the
Do you
court.
have anything else pending?
No, Your Honor. No. And all I can say about this particular case, Your Honor, is I think whoever the judge at the prelim is going to find the video very interesting.
Okay, with the understanding that there's been a change in circumstance on this, I'll grant the request to remove the GPS tether. So we'll prepare an order and let them know so you can get that removed even before you leave here. Just go over. Yes. Okay. I'll set preliminary examination in this matter, March 10th, 2026, 9 a.m. before Judge Garwood. His bond and its monetary amount will continue without fee.
Thank you.
Thank you. Go to my court calls case People versus John Marks.
David I. Goldstein, appearing on behalf of the defendant.
Your name? John Marks. Thank you.
We're setting this matter for exam, Your Honor. I do have discovery.
People, other witnesses available March 10th.
Do our best, Your Honor.
Preliminary examination in person, March 10th, 2026, 9 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you. Bond continue. Calls case People versus Javante Cadell.
Morning, I'm Rob Dickel on behalf of Mr. Cadell. Javante, would you state your name on the podium? My name is Javante Cadell. Judge, we're asking to set this matter for exam.
Discovery is complete.
Yes, sure.
People have their witnesses available February 10th.
Do our best, Your Honor.
Judge, may I address bond?
Preliminary examination in person will be set February 10th, 2026, 9 a.m. before Judge Fresh Hour. As to bond.
Judge, this young man's 18. He has no criminal record, juvenile record. It's my understanding, he was living at Ozone, who was trying to place him with his own apartment. I understand there's a $10,000 bond because he missed a court date. He did not have a ride at that time. What I'm asking the court is, I've spoken to this young man. He promises to appear for all future court hearings. Would like to get back to the Ozone so he doesn't lose his place as far as getting a placement, and he can be gainfully employed. We would just ask the court to set a PR bond in this matter.
Any response from the people?
Your Honor, I'll leave it to the court's discretion. If it helps the court decision making at all, the co-defendant's case that was set for claim on Tuesday got dismissed because we were unable to proceed at that time.
Got it. How do you come back into custody?
Were you arrested or did you? I was arrested, sir. My caseworker was supposed to call due to the weather conditions. He said he called, but I guess, but I was picked up, sir.
What were you doing when you were picked up?
Trying to get to one of my friend's house.
But here's the legal reality. Missing court is one of the fastest ways to get slammed with a higher bond or a warrant. The judge did give him a break, but you can hear the warning. Don't make me regret this. Viewers, was the judge being fair, or was that a little too much courtroom roasting?
Yes, sir. I tried to make it to court. The weather conditions was hard. I ain't have a phone. It was cold. My phone died, sir. And I tried to, my my caseworker, he tried to help me too, make sure I made it to court, but he couldn't help me.
You grew up in Michigan?
You said what, sir?
Did you grow up in Michigan?
Yes, sir. You're going to appear for our future.
If it was too cold, then we're getting soft.
Nah, it wasn't even just that. I didn't have the right clothing either, sir. And I was building
I got you.
through the distance.
I got you. Well, reinstate his previous bond. I'll grant the reduction. Reinstate his previous bond, but you better show up on the 10th. You hear me?
Yes, sir.
You got to start out walking on the 9th. You better show up on the 10th.
Yes, sir. You call me, okay? No, sir. Let me just see real quick.
Those previous bonds reinstated.
See right away here, boss.
Court does call the case People versus Gary Coward.
Morning again, your Honorable Court, David Williams, on behalf of Gary Coward.
Gary Coward.
Thank you. Your Honor, myself and Mr. Chavalowski are trying to resolve it at the district court level. If I can come back on the 12th, I'm back here again, Judge.
Probable cause conference without objection will be adjourned February 12th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. Text you.
Court calls the case of the People versus Caitlin Quinn.
You were right. I was wrong.
Morning, Your Honor. For the record, Brian Stacy, P 33014. State your name.
Caitlin Quinn.
All right, I have before me a plea form that indicates that she's going to be pleading guilty to the charge of use of methamphetamine, the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's, of course, full understanding of the.
That's accurate, Judge. I have had an opportunity to explain to my client her rights in detail. I believe she understands them and at this time has knowingly, voluntarily waived them and lay a factual basis to the added count.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Caitlin Quinn.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration at $2,000 fine plus court cost. You understand that?
Yes, Your Honor.
All right. In understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct? Or had one signed on your behalf?
Yep, yes, Your Honor, yep.
All right. Any question regarding any of those rights?
No, Your Honor.
You understand you're giving up those rights on that form,
Yes, Your Honor.
particularly the rights contained in paragraph 5. If you look on the podium, you'll see a copy of the advice of rights. Understand you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes,
and because you believe that you are indeed guilty of this offense?
yes, Your Honor.
On the date of September 4th, 2025, Washington Hogback Road, Pittsfield Township, Washington County, State of Michigan, did you have methamphetamine in your possession?
Yes, I did, Your Honor.
Did you use it?
I did, Your Honor.
And did you know what you were using was methamphetamine?
Yes, I did, Your Honor.
All right. Ma'am, if I accept your plea, I have to advise you that if you commit misconduct between, as defined by the Michigan court rules, between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not aware of any, Judge.
All right. And have I complied with the court rule?
And defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be set for February 11th, 2026, 9 a.m. That's before me.
And that's here, Judge, correct?
That is correct.
And Your Honor, can I address bond?
Briefly.
Judge, briefly, my client has no prior offenses. The test did come back, the one that she appealed, and it showed the progress report. It said victims report negative for fentanyl. And I think that was one of the issues that the court kept her. And I think she would acknowledge that she did use cocaine after.
No, there's. Well, go ahead, counsel.
No, and I think she would acknowledge that she used cocaine after being placed on bond initially when you put her in jail, since she's been in jail since January 8th. And she also, Judge, has been diagnosed. She was taken to the hospital while in custody for gallstones. Apparently she does not have any gallstones, but she has blood in her urine, and the doctors believe that she has kidney stones. So she does need medical attention. And she was hoping her daughter's 15 years old, she's homeschooled, and her grandmother is 86 years old, and she's been diagnosed with Alzheimer's, and she was hoping to move in with her, and her daughter would be with her and to help take care of her grandmother. Her mother, I believe, is.
Are you going to be able to test clean if I let you out?
Yes, sir. I've learned my lesson, Your Honor.
I'll reinstate her previous bond with the testing, and so she'll be released on PO.
Thank you very much for your consideration today, Judge. You have a good day.
You do the same.
Thank you.
Court does call the case People versus Jennifer Burnside.
The people.
Morning, Your Honor. Jason Hagelthorne on behalf of defendant Jennifer Bernstein, who's present standing.
Morning, Your
by.
Honor.
Good morning. Your name?
Jennifer Burnside.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of operating while intoxicated, second offense, the 1 year. On her successful plea to that charge, counts 1 and 2 would be dismissed. Defendant agrees to enroll and participate in the 14A sobriety court. There is also a sentence agreement. well, it just says the 14A, it says A3, but it's 14A sobriety court. Defendant has been accepted as of January 29, 2026. That's, and there is a sentencing judge where we checked off. That is the court's full understanding of the agreement.
Yes, Your Honor.
Yes.
May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Jennifer Burnside.
All right, ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration, up to $1,000 fine plus court costs. The court could order any rehabilitative services or community service the court deems necessary. The court could also order your vehicle forfeited or could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. Do you understand all of that?
I do, Your Honor.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that?
I do, Your Honor.
You wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty?
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
I did, Your Honor.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily
I am, Your Honor.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
April 10th, 2025, at the location of I-94 near Freer Road in Sylvan Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, you consumed, I guess, alcohol and cocaine
I did, Your Honor.
and THC also.
Yes,
Is that correct?
Yes.
All right. Were you stopped by the police?
Yes, I was.
All right. Why'd they stop you?
My turn signal was burned out when I went to go get on the highway.
All right. Were you arrested?
I was, Your Honor.
Were you taken to the hospital for a blood draw?
I was, Your Honor.
And what were the results of that blood draw regarding alcohol?
0.97, 0.097.
0.097. All right. Did it also show the presence of cocaine or its derivatives as well as THC and or its derivatives?
Yes, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. And ma'am, had you previously been convicted of operating while intoxicated on or about June 25th, 2023 in the 53rd District Court and operating while impaired on or about February 25th, 2006 in Farmington Hills District Court?
Yes, Your Honor.
All right. Ma'am, if I accept your plea, I do have to advise you if you commit misconduct between the time I accept your plea and the time of sentencing in this matter, that the court, that you would not be entitled to withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No. All right. And have I complied with the court?
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 3, excuse me. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be March 9th, 2026, 9 a.m. before Judge Freshour. On will continue.
Your Honor, I did have one request renewed from the last time we were here. Ms. Burnside has a pretty severe cut. I know the probation, the testing facility, Keith over there had checked it. He has recommended her, and I believe he's going to accompany her to medical for that. They did switch the leg, but based on that, would the court be willing to transfer to the sober link and a release of that tether?
Response from the people.
Judge, we'd ask, being a photo maker and going to this sobriety court, we'd ask that the tether remain. If the court is willing, Mr. Heaton did give us a possible sentencing date of February 12th. and then Judge Fred.
That date can be moved up. I'm not moving it up because I don't have a date.
Fair enough. I just-
So you guys can do that, and if you can get it moved up, then that's fine, and I'm not gonna remove the tether. Her bond will continue as is. Thank you.
Thank you, Your Honor.
I just need a form on that.
Yeah, okay.
Court does call the case People versus Marquetta Clement.
Okay, welcome to the people.
Good morning, Your Honor. Assistant Public Defender Alexis Erbs with and on behalf of Ms. Clements, who's approaching. Can you please state your name for the record?
Marquetta Clements.
Thank you. You're requesting an adjournment?
Yes, Your Honor, to engage in some plea discussions, and I'd like to address bond when appropriate.
Probable cause conference will be adjourned February 12th, 2026, 9 a.m. As to bond.
Thank you, Your Honor. Ms. Clements is in custody based on a prior failure to appear at a probable cause conference on September 11th. It's my understanding that after this alleged incident took place, she was hospitalized at St. Joe's, and then St. Joe's transferred her to Stonecrest, and she was in Stonecrest from September 9th to September 26th. She was suffering from long-term memory loss. She had a concussion, and she was having some other mental health issues. I did try reaching out to both of the facilities. I sent releases of information to both. I haven't gotten any records back at this time. But once she was released from Stonecrest, she was working with leaf harm reduction. She can either stay with a friend in Ann Arbor, Your Honor, or she can stay at the Delonis. She does provide me this address. And
How'd she come back into custody?
How were you brought back?
Officer just took me off the bus, no reason. I wasn't in no trouble.
So, Your Honor, I believe in that.
He just came on the bus and grabbed you?
Asked Officer Lawrence, he did.
Because he knew you had a warrant.
He knew I had a warrant, but I didn't know I had a warrant at the time.
So, Your Honor, with that, I would say that there was no new charges when she was brought into custody. It was just officer recognition and being aware that she had the warrant, so they brought her in on the warrant. Like I said, Your Honor, I'm still waiting back on any of those records, but at this
So I
point.
don't have any medical to verify what you're saying, and she was gone for about 4 months.
Yes, Your Honor, but I'm hoping those records will be here very soon. Like I said, I sent releases of information to both
But
St.
those
Joe's.
records aren't going to explain the 4 months. No answer needed. I don't need a response. Motion for bond reduction denied. Bond voted. Thank you. Court calls case People versus Abdul Latif. You know what? You keep talking. You want me to up it? Oh, give me the file. She wants to be smart. You can just let her know her bond's revoked. Mark the file.
Thank you, Your Honor.
The court calls the case People versus Johnny Kane.
You're ready to talk to the people?
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Payne, Your Honor.
Her name, sir?
Johnny Charles Payne.
Your Honor, this is a matter we have reached a resolution. Looking for the paperwork now. I just had in my hands. Here it is. Of use of a controlled substance. I have him executing the plea form and the advice of rights. Now, I have gone over his rights. I have gone over his rights with him. Get it. And explained to him that all those rights. Your Honor, this is, I've seen a picture of the analysis. I don't have the report. I don't know that the labs have gone to the crime lab. I've explained that to Mr. Payne. He still wishes to issue a plea, enter a plea, if I may approach.
You may.
He is on parole, Your Honor. I've explained to him.
I'll get to it. Thank you. The plea form that the court has in its hands indicates that the defendant's going to be pleading guilty to an added count 2 of use of methamphetamine, that the 1-year offense. Upon a successful plea to that charge, count 1, the possession charge would be dismissed. There is prosecutor and defense facts agree to a sentence of time served. However, I would indicate that taking the plea, I could not find the sentencing judge to that recommendation. And that, sir?
I do, Your Honor.
All right. May I have him sworn?
solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth.
It is this court to understand you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that, sir?
I do.
You understand also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
I do.
Still wish to plead guilty?
I do, Your Honor.
And to that charge, how do you plead?
I do plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind, any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation?
No, sir.
Are you on parole?
I am.
You understand that your entry of a plea in this case could be a violation of that parole?
I do.
You understand that as such, you could be sent back to do the remainder of your term?
I do.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
They have not.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily?
I am.
Of your own free will?
I am.
And also because you believe that you're guilty?
I do.
All right. On the date of December 12th, 2025, location of Barton Drive near Pontiac Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
I did.
Had you used it?
I had.
And did you know what you were using was methamphetamine?
I did.
All right. Sir, I do have by the Michigan court rules that you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not, Judge.
All right. And have I complied with the court rule?
Yes, Your Honor.
Defense is satisfied the court has complied with the court.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be February 27th, 2026, 8:30 before Judge Perry. The bond will continue. Thank you. Thank you, sir.
Thank you, Your Honor.
You're welcome, sir. Court calls case of the people versus Jessica Brisgalia.
Good morning, Your Honor. Assistant Public Defender Alexis Earps with and on behalf Ms. Brosgala, who I believe should be appearing on Zoom.
Gala.
Okay, hi, can you hear me?
Yeah, we can hear you.
Okay, Jessica Bruscella.
Your Honor, we'd be requesting an adjournment this time. There's some more.
She's gonna need to, let me just stop you. She's gonna need to appear in person. We've had a problem with this defendant. She was smoking.
That wasn't me.
Folks, my staff has reported that was you. And
No,
it appeared as though you were having sex on the screen.
No.
Well, it was interesting. The reason I took a break was to go back and look at the video. And my staff reported it to me, and it did appear that that's what was occurring. To next week, the 5th, you'll have to appear in person, ma'am.
Okay.
That way we can assure you're not smoking and not having sex while you're in court. Thank you. Bond will continue.
Understood, Your Honor. Thank you.
Wow.
Yeah. Wow. You should see the video. All right. Thank you. Mute her and get her out of my court.